Sexual Harassment and Abusive Conduct Prevention Training. I'm your presenter today. My name is Christian Robbins. I am a Senior HR and Risk Manager for ZAMP HR. I've been with ZAMP HR for approximately 4 years, and prior to that, I worked as Regional Operations Manager for a large distributor, ran the western half of the United States, worked previously for a large casting foundry as their Director of HR Safety and Workers' Comp, had other HR and safety manager positions over the last 25 years, also had the opportunity to lecture at Unimontes, which is a state university in Brazil. That was from 2004 to 2006. I've been self-employed and owned several of my own businesses, but for the last 15 years, I've really specialized in making workplaces more productive, changing culture, increasing employee satisfaction and performance, and helping businesses come into compliance with state and federal requirements. So my experience is quite broad, from foundries to construction to software. A lot of experience writing and implementing policies, as well as training, and fluent in English, Portuguese, and Spanish. So today we're going to talk a little bit about sexual harassment and abusive conduct prevention. And the presentation today is based on the law in California. So during this training, we will review the elements of sexual harassment and the remedies available to victims of sexual harassment under both California and federal laws. We'll discuss forms of unlawful harassment. We'll consider strategies for preventing and responding to unlawful harassment. And we'll also address concerns regarding abusive conduct in the workplace. And during this presentation, how we'll do that is there'll be several scenarios that we'll present, several questions in the form of quizzes that we'll go through to give you a broad overview of what sexual harassment is, the definition, and how you can spot it and how we can also avoid it. So we'll start with the overview of laws against sexual harassment. And once again, most of this presentation is based on the California law, and we'll get into that after this first quiz. So this is the first true or false quiz. There'll be several of these questions in a separate quiz at the end of our presentation, just to make sure you are paying attention. So if you pay attention to these questions here, I'm sure you'll do very well on that quiz at the end. Number 1, individuals can be personally liable for sexual harassment. True or false? And number 2, volunteers and unpaid interns are not protected against sexual harassment. Well, here's the answers. It is true, individuals can be held personally liable for sexual harassment. So if you're a harasser, you can be held personally liable. And false, volunteers and unpaid interns are protected against sexual harassment. And we'll talk about that a little bit as we go forward. So under the law, these are the people that are protected. Employees, applicants, and that's applicants for jobs. So not someone that's been hired that is an employee, but someone that's just applying. Contractors are protected, volunteers, and unpaid interns are also protected by the law. Liability under the law? Well, every employer or prospective employer, so that's the employer that's interviewing, and every person in the workplace, a supervisor, a subordinate, a coworker, they can all be found liable for sexual harassment and be personally liable for the damages caused by that unlawful harassment. Personal liability of the harasser. The individual harasser is personally liable for the damages caused by his or her unlawful actions. And so the real point of this training is to make sure that we're not harassing, because we don't want to be personally liable for that. Liability of the employer. The employer is also strictly liable for unlawful harassment by supervisors and agents. And a supervisor under the California Fair Employment and Housing Act is anyone that has the discretion and authority, and here's the few parts. A, if someone can hire, transfer, promote, assign, reward, discipline, or discharge other employees, or if they can effectively recommend any of those actions, they're qualified as a supervisor. B, to act on grievances of other employees or to effectively recommend action on grievances. They are considered a supervisor. And C, to direct the claimant's daily work activities. That is also a definition of a supervisor. And this all comes back to the liability of the employer. So there's also harassment out there by non-supervisory employees, and employers can be liable for that harassment by non-supervisory employees if the employer knew, or if the employer should have known about the harassing behavior and failed to take immediate and effective corrective action. So any harassment that's taking place in the workplace, the employer can be liable for that. And that's the test right there. If they knew, they're liable. If they should have known, they're liable. So illegal harassment is really the conduct or action towards a protected class, and it has to create a hostile or abusive or intimidating work environment. There are two forms of sexual harassment that we're going to look at in detail, and it's defined by case laws in these two ways, one being quid pro quo and the other hostile work environment, and we'll go into those. So under quid pro quo, you have first demanding sexual favors in exchange for employment benefits. So that would be, hey, if you give me sexual favors, I will give you a job. That is quid pro quo. Or number two, demanding sexual favors by threatening negative employment actions. For example, give me sexual favors or I will end your employment. Hostile work environment, three scenarios there. Harassing behavior directed towards the complainant. So that's someone that's raised a complaint. They're being harassed because of it. Harassing behavior witnessed by the complainant. So this might be a third party that's witnessed sexual harassment or harassment, and they've complained. And the third would be widespread sexual favoritism that infects the workplace, creating a hostile or abusive environment. And as the presentation progresses, we will talk about different scenarios for each of these types of harassment, the quid pro quo, and also hostile work environment. So there are remedies for harassment, and the first of those would be injunctive relief. That would include training. That would include maybe different policies or procedures in the workplace. There's economic damages that can be recovered, such as lost wages, medical expenses, or job search expenses. There are non-economic damages. So, for example, emotional distress or loss of enjoyment of life. And then finally, punitive damages. So there are several protected classes that we'll talk about during this training. And those protected classes are generally race, religion, gender, natural origin, age, disability, genetic information, military veteran status. So this is under the federal law. Under California law, we will actually look at a larger list further along in the presentation. But first of all, what we're going to do is we're going to take a look at quid pro quo and talk about several different scenarios. So let's start with a quiz, and this would be the second quiz, quiz number 2. Also true or false. Number 1, the promise of reward or threat of punishment in exchange for sexual favors It has to be explicit in order to constitute quid pro quo sexual harassment. True or false? Number 2, an employee who gives in to the demand for sex in order to avoid negative consequences forfeits his or her claim for quid pro quo sexual harassment. True or false? And the third, if the alleged harasser denies the charge, a claim for sexual harassment cannot be successful without a neutral witness or documentary evidence supporting the complainant's accusations. Is that true or false? Well, let's give it a whirl and see. Here are the answers to quiz number 2. So the first one is false. The promise of reward or threat of punishment in exchange for sexual favors does not have to be explicit in order to constitute quid pro quo sexual harassment. The second one is also false. An employee who gives in to the demand for sex in order to avoid a negative consequence has not forfeit his or her claim for quid pro quo sexual harassment. And the third item was also false. If the alleged harasser denies the charge, a claim for sexual harassment can still be successful even without a neutral witness or documentary evidence supporting the complainant's accusations. And that will be by way of investigation. So, quid pro quo, the essence of a quid pro quo sexual harassment claim is that a supervisor relies on his or her apparent or actual authority to extort sexual favors from an employee. And the threat can be expressed or it can be implied. It doesn't have to be direct. So let's talk about a scenario. And this is a scenario that we've put together just to kind of talk about how sexual harassment works. So Rob, he's the sole proprietor of ACO. He's decided to grow his business and compete for state contracts. So Rob goes out and finds Jack. Jack's an independent contractor, and he signs a contract with Jack to install a computer network. He also throws some ads out there. One's for an office manager, and Mary responds to Rob's ad for office manager. Well, Rob decides that he's going to threaten Jack with a lawsuit for breach of contract unless Jack agrees to engage in sexual activity. Then Rob goes and tells Mary, hey, I'll give you this job if you agree to have sex. Well, let's talk about what the best answer there is. What's going on? And we've got 5 options, A, B, C, D, and E. And there is one answer that is the best answer of those. So, is it A, Jack can't sue Rob because he's an independent contractor? Mary can't sue Rob because ACO has fewer than 5 employees? Jack can't sue Rob because he's a man? Jack and Mary can sue Rob for quid pro quo sexual harassment. Jack can sue Rob for quid pro quo sexual harassment, but Mary cannot. Well, as we look at those scenarios, I believe that D is the best answer. Jack and Mary can both sue Rob for quid pro quo sexual harassment because he said that he would sue Jack for breach of contract if he didn't engage in sexual activity, and he also said he would only give Mary the job if she engaged in sexual harassment, which is quid pro quo. Here is our second exercise, exercise B. And this is Sarah. She is the deputy director of a state agency. And she approaches Nancy, who's an office technician, and says, "Hi, Nancy, I've seen you at the gym. You seem to have a great time in Zumba. And so sexy. Nancy, I'd love to take you to Tahoe this weekend. Just the 2 of us." Well, Nancy's stunned, but also intimidated by the attention. And she says, "Well, Sarah, I'm flattered, but I'm just not interested." Well, Sarah smiles wanly and says, "Well, I had to ask. You are just so sexy, but I get it. I'll leave you alone." Sarah does not proposition or engage in any unwelcome conduct towards Nancy again. 3 months later, Nancy is late for work for 3 days, and her supervisor, which would be Sarah, threatens to deny her MSA if she is late again. Let's talk about the best answer here. Nancy can establish a claim for quid pro quo sexual harassment because Sarah should have never asked a subordinate on a date. Nancy cannot establish a claim for quid pro quo sexual harassment because there is no evidence that she is a lesbian. Nancy's claim for quid pro quo sexual harassment is weak because there is no evidence that Sarah was offering job benefits if Nancy said yes, or threatening punishment if Nancy said no. Well, C is the best option there, of course. Nancy's claim for quid pro quo sexual harassment is weak because there is no evidence of the quid pro quo, or this for that. No evidence that Sarah was offering job benefits if she said yes, or threatening punishment if Nancy said no. So let's take a little look at hostile work environment and how that's different from quid pro quo. This would be our third true or false quiz. And we're going to look at 2 questions here. 1, to prove hostile work environment sexual harassment, the complaining party does not need to show they suffered an adverse employment action. True or false? And 2, to prove hostile work environment sexual harassment, the complaining party must show that they were subjected to unwanted sexual attention that was both severe and pervasive. Is that true or false? Let's take a look. Answers. Well, true. To provide a hostile work environment sexual harassment, the complaining party does not need to show that they suffered an adverse employment action. So there doesn't have to be something bad that happened at work due to the hostile work environment. We just have to prove that it's a hostile work environment. And the second, false, the complaining party, it does not have to be severe and pervasive. So to prove hostile work environment sexual harassment, the complaining party only has to show that they were subjected to unwanted sexual attention. It doesn't have to be severe, it doesn't have to be pervasive. So the 3 varieties of hostile work environment sexual harassment that have been recognized by the courts are hostile work environment conduct directed at claimant, hostile work environment conduct directed at others, and hostile work environment widespread sexual favoritism. The harassing conduct, this is the explanation that we're going to go into now, and we'll explain for the 3 different ways that it can happen: verbal, visual, and physical. Harassing conduct includes unwanted sexual advances in those 3 ways: verbal, visual, and physical. So verbal can be foul or obscene language. It can also be derogatory comments. It can be explicit discussions about sexual activities. It can also be comments about other people's physical attributes. So all those are verbal, hostile work environment cues. Visual hostile work environment cues are things such as leering, staring, making sexual gestures, displaying sexually explicit objects or pictures or cartoons or graffiti or posters. And it can also be sending graphic emails, text messages, or sending jokes. And the last part, physical. This would be kissing, hugging, grabbing, impeding or blocking movement, or assault. So let's take a look at another scenario here in exercise C regarding hostile work environment. Tamika starts as a supervisor for the commission in Yuba County. The other 4 supervisors and all the field crews at Yuba County office are men. Eve, the district administrator, does not think women should be field supervisors and resents that headquarters is forcing an affirmative action case on her office. Eve tells the other supervisors and crew members, the field is no place for a woman. She tells Tamika's crew, keep an eye on her and use your judgment in the field. During office meetings, around the office, and in emails, Eve consistently refers to Tamika as Little One, Wonder Girl, Oprah Jr., and similar names. Well, Tamika tells Eve that she's being undermined, and that Eve's doing the undermining. Eve tells her to grow a pair or you'll never make it out there. So let's talk about this scenario and decide which of these 3 items is the best at describing what's going on here. A, Eve's use of a diminutive nickname and undermining of Tamika's authority is okay because Tamika needs to demonstrate the ability to supervise men in what can be an inherently crude environment. Or B, Eve's nicknames and statements undermining Tamika's authority have created a hostile work environment. Or C, because Eve has no interest in Tamika sexually, her hostile behavior is not actionable as sexual harassment. Well, the best answer would be B. Eve's nicknames and statements undermining Tamika's authority have created a hostile work environment. All right, so this is continuing with the same individuals and a continuation of the scenario. So Warren, he's a member of Tamika's crew. He frequently refuses to follow her orders and says, "Your boss told me to use my own judgment." Warren and Ben, another employee, routinely interrupt team meetings by burping, talking, and laughing. And then they sincerely offer apologies, saying, "Apologies to your ladyship." Frank tells Warren and Ben, he's another team member, "Leave my gal alone." Frank repeatedly comments on Tamika's appearance, saying things like, "You are the hottest boss I've ever had." Or, "Dollface, you can tell me what to do whenever and wherever you want." He repeatedly asks her out, even though Tamika makes it clear that she is very happily married. So Tamika is afraid to call Eve on her behavior, but complains about the treatment by her crew. Eve takes her written complaint, but then takes no action. Well, let's pick the scenario here that best describes what's going on. A, Frank cannot be found liable for hostile work environment sexual harassment because he is defending Tamika. So Frank was the one that said, "Hey, don't be talking that way about my supervisor." Warren and Ben aren't liable for sexual harassment because there is no evidence that their disruptive actions are substantially motivated by Tamika's sex. Besides, their actions are neither severe nor pervasive. And C, the commission is liable for the sexual harassment of Warren, Ben, and Frank because management knew or should have known of their behavior. Well, the answer is C. The commission is liable for the sexual harassment of Warren, Ben, and Frank because management knew, that would be Eve, or they should have known about the bad behavior. And severe pervasive, to be actionable, the unwanted behavior must be severe or pervasive and alter the conditions of employment to the extent that it creates a hostile or abusive work environment. Let's consider the nature of the conduct, the frequency of the conduct, the period of time over which that conduct occurred, whether the conduct was physically threatening or humiliating, and the extent to which the conduct unreasonably interfered with an employee's work performance. All right, new scenario. Cody, he is a unit supervisor for the board. Drew is an office technician. He sits in a row of 5 open workstations right outside Cody's office. On Drew's first day, Cody gives Logan, who's another office technician, a lingering hug and kiss on the lips. Cody says, while looking Drew up and down, "Welcome to Cody's world. If you remember just one rule, what Cody wants, Cody gets, you'll have a bright future here." The next day, Logan arrives early for work to be seated before Cody arrives. But Cody starts rubbing Logan's shoulders and says, "You can't stay seated forever." Drew sees and hears these interactions. Logan tells Drew what's happening, and Drew says, "Just get over it." Drew starts losing sleep and misses work because of Cody's mistreatment of Logan. All right, what's the best answer for this scenario? Drew cannot state a claim for hostile work environment because Drew told Logan not to complain. Drew has personally witnessed Cody's harassment of Logan and therefore can sue Cody and the board for sexual harassment due to a hostile work environment. Well, the answer there, of course, is B. Drew has personally witnessed Cody's harassment of Logan, and therefore he can sue Cody and the board for sexual harassment due to a hostile work environment. Continuing with Cody, exercise F. Cody and 2 office technicians, Parker and Rachel, are openly in a sexual relationship. Cody regularly calls them to the office for special consultations. Their sexual congress is audible through the door. Cody gives Parker and Rachel preferred shifts, bonuses, and training that's denied to the others. Cody also allows Parker and Rachel to use Drew and Logan and Timothy, another office technician, to do their work and to run their personal errands. Drew, Logan, and Timothy are disgusted, but they work together to make sure they excel at all their assignments. Well, the best scenario here is Drew, Logan, and Timothy can successfully sue Cody, Parker, Rachel, and their employer, the board, for sexual harassment or hostile work environment. Widespread sexual favoritism, which is the third form of sexual harassment work environment that we talked about. So, key concepts of these different types of sexual harassment. Let's start with a quiz to see what we've understood so far. Sexual desire is a key element to any claim for sexual harassment. True or false? an employee can file a claim for sexual harassment even if the supervisor took no adverse employment action. There was no termination or failure to hire or demotion against the employee. True or false? So false. Sexual desire is not a key element to any claim for sexual harassment. And true, an employee can file a claim for sexual harassment even if the supervisor didn't take adverse employment action against them. Termination, failure to hire, demotion. So, sexual harassment is not required. Recent legislation clarified the existing law by expressly stating sexual harassing conduct need not be motivated by sexual desire. And the legislation, SB 292, Corbett, was passed to repudiate the contrary decision from 2011. So, adverse employment action not required. The complainant does not have to have tangible economic loss or other adverse employment action. The crux of the harassment claim is the assault on the complainant's personal sense of dignity and well-being. And we can think back to that scenario where Drew came to work and Cody was harassing Logan. Drew did not suffer a tangible economic loss or other adverse employment action, but it assaulted his personal sense of dignity and well-being. So let's talk about denials and defenses. So, true or false? In California, if the employee does not take advantage of the established internal complaint process, the employer has a complete defense to an action for sexual harassment. True or false? It's false. So this just means that in California, if you don't take advantage of the established internal complaint process, you can still have the employer will not have a complete defense for sexual harassment action. You can complain inside the established internal complaint process, or you can complain outside the established internal complaint process. Denials. So these are common responses to charges of sexual harassment and a denial of the charges. People say, it never happened. Or you can't prove it, there's no witnesses. They'll also try and blame it on the complainant. Well, look how she dresses. Or they'll try and downplay their behavior. Hey, I'm a hugger. Or another way of blaming it on the complainant is, have you ever heard of a woman scorned? If I don't tell her she's hot, she's not going to get the job done. Let's look at another scenario here. Sam, he's a senior supervisor for the department, and he calls Maggie into his office. He tells her that if she'd like to avoid a bad review, she must perform a sexual act with him. He grabs her and pushes her to the ground. Maggie manages to escape Sam's grasp and flees. Jose sees Maggie running out of Sam's office in distress and thinks her blouse may have been partially off. Katie sees Maggie in the restroom crying and fixing a tear in her blouse. Maggie tells Katie about the attack. Sam abruptly promotes Maggie. Well, Katie and Jose tell an equal employment opportunity officer what they saw and heard. Sam denies that it ever happened. Maggie files a complaint with the California Department of Fair Employment and Housing, alleging quid pro quo sexual harassment. Well, it is quid pro quo sexual harassment, and a reasonable investigator would conclude, based on the circumstantial evidence and the credibility assessments, that quid pro quo sexual harassment did occur in this case. Let's talk about the defense, the lack of action by the victim. So the victim could have avoided part or most of the harm if they had taken advantage of the employer's procedures for addressing sexual harassment. Avoidable consequences doctrine. The amount of harm to the victim could have been less if the employee had taken action. Failure to mitigate damages. Well, let's look at this scenario and see what we can glean from it. ABC Company, they provide all the employees with a handbook that details ABC's zero tolerance sexual harassment policy. They instruct employees to call ABC's HR department immediately if they experience or witness any type of sexual harassment. Quinn, he's an ABC supervisor, he walks by Pat's desk and he whispers to Pat that he should forget to wear undergarments the next day. Pat, shocked, pretends not to have heard. From then on, Quinn whispers similar comments to Pat every opportunity when they're alone in the office. Pat does nothing, and he thinks it's only a matter of time before Quinn, who is an incompetent supervisor, is replaced. Well, after 6 months, Quinn is terminated for poor performance, at which point Pat recounts all of Quinn's past actions to a senior executive and asks the manager to make sure the next supervisor is less disgusting. Whew, the best answer. Pat cannot sue anyone for sexual harassment because 6 months have gone by and Pat waited until Quinn was fired before anything was shared with management. Pat can sue both Quinn and ABC, but ABC can try and reduce the amount it must pay by arguing that the harassment would have been stopped if Pat called HR after Quinn's first comment. Or Pat can only bring a claim against Quinn. ABC is not liable because Pat chose not to follow the instructions in the employee handbook. The best answer here is B. Pat can sue Quinn and ABC. ABC can try to reduce the amount that they're liable by arguing that the harassment would have been stopped if Pat had called HR after Quinn's first comment. Well, let's do a little bit of comparing here between the federal and California state sexual harassment laws. So, quiz here to kind of set the stage for what some of the differences are. Unpaid interns and volunteers are protected under federal laws against sexual harassment. California law is broader than federal law in providing protection against sexual harassment. Both of those are true or false. So, false. Unpaid interns and volunteers are protected under federal law against sexual harassment. They are not explicitly protected under federal law, where under California state law, they are. And California law is much broader than the federal law in providing protection against sexual harassment. So here's a quick side-by-side of federal Title VII and California FEHA. So in the federal Title VII, the negligence theory only, the employer is not automatically liable. The employer is not liable if the employer exercised reasonable care and an employee unreasonably failed to take advantage of opportunities to avoid harm. Federal Title VII requires 15 employees or more, as well as no application to independent contractors, volunteers, or unpaid interns. The California FEHA is strict liability of the employer. The employer is automatically liable for any harassment by supervisors or managers. The employer has no defense if a manager or supervisor is a harasser. And all employers, even those employing one person or sole proprietors, are protected. And that includes independent contractors, volunteers, and unpaid interns as well. So let's look at some other types of harassment. Starting with a quiz. True or false? Quiz number 7. California law identifies 17 specific protected bases for employment discrimination, harassment, and retaliation. True or false? Number 2, sex, sexual orientation, gender identity, and gender expression are all protected bases under the FEHA. True or false? Both of these are true. California law does identify 17 specific protected bases for employment discrimination, harassment, and retaliation. And it's also true that sex, sexual orientation, gender identity, and gender expression are all protected bases under the FEHA. Illegal harassment. Let's go through this and talk about some specific examples as we look at what harassment is. Discrimination due to protected class status, to include sexist conduct, racist conduct, and also to include sexual orientation and gender identity issues. So racist conduct, that would be use of racial terms or name calling, the use of racial figures of speech, racial or cultural joke telling, segregating employees based upon race, making fun of coworkers, making fun of their foreign accents. Sexual orientation would be the next. Teasing or taunting an employee for a real or perceived sexual orientation or gender identity. Name calling. And then gossiping about, are they? Aren't they? And the suppositions that would go along with that. Religious issues, making negative comments about a particular religious belief or practice. Inappropriate conversations in the workplace on religious topics that alienate those that don't share the same beliefs, which would also be considered proselytizing. Discrimination due to disability, gender, association, and age. So, disability-based harassment would be isolating someone with a disability, teasing them, making patronizing comments, refusing to reasonably accommodate that disability, reasonably accommodating but putting conditions to that accommodation. Gender association, any teasing or taunting of employees in roles that might historically be dominated by one gender or the other. Gender assigned job titles like male man. Passing up an individual for promotion due to gender association. There's also age-based harassment, which would be making negative comments or references based on age. Hey, Grandpa. Inappropriate isolation of exclusion based on age. Gestures to imitate. So let's say maybe they walk curved or walk slowly. Unfair criticism. There's also physical harassment, violence or threats of violence, horseplay, destruction of property, personal harassment, verbal harassment, and this wouldn't have to be based on a protected class, just something that creates a hostile work environment, might be inappropriate comments or jokes, could be publicly humiliating, using intimidation tactics to get someone to do things at work or just to make them feel bad, ostracizing, so making it so that people don't feel included, bullying, yelling, cursing, being mean, or generally unpleasant to other people. There's also power harassment. That would be a boss or manager to subordinate. Doesn't have to be real power, it only has to be perceived. So it could be coworkers that are equal, but for some reason someone has perceived power, maybe because they've been there longer. Making impossible demands of employees, that would be power harassment. So setting deadlines or giving too much work that can't be completed during those deadlines. Humiliation, bringing people's personal life into the workplace. There's also psychological harassment. You can isolate them, you can make them a pariah, you can trivialize their contributions, you can belittle their ideas, use intimidation tactics, or just generally gossip about people. Cyber harassment, that might be mass humiliation by posting to social media, making false claims on social media, or cyberbullying in general. There's retaliatory or retaliation harassment, and that would be getting payback or revenge for reporting some harassment, and that's the tit for tat payback. So, oh, you did this to me, but I'm going to do this to you. And it could be also that you're upping the ante. So someone did, well, he did this, that, and the other thing, and then you come back with, well, he did this, that, the other thing, plus one more. There's also third-party harassment from a vendor, a supplier, or a customer, a client. So harassment based on any of the characteristics listed below is illegal. Race, color, national origin, sex, sexual orientation, gender, gender identity, gender expression, religious creed, mental disability, physical disability, a medical condition, military or veteran status, marital status, age, genetic characteristics, or ancestry. And those are the 17 points under the FEHA. Let's look at a scenario here. Carl has been a manager for the board for 5 years. Carl approaches another manager, Terry, and tells him that she identifies as a transgender woman and is beginning the process of transitioning at work. From now on, Carl would like to be called K and will be wearing clothing consistent with an identity as a woman and prefers the use of feminine pronouns. As the week passes, Kay's coworkers become accustomed to her new name and appearance. Sometimes they inadvertently refer to Kay as Carl, and sometimes they use the masculine pronoun he, especially when they're telling stories about things that had happened before Kay's transition. Usually the coworkers are quick to correct themselves when it happens. Terry, however, pointedly says, "Good morning, Carl," when Kay passes by. And he makes comments like, "Nice dress, dude." Kay is embarrassed but says nothing to Terry or anyone else about these comments for months. So what advice would you give Kay? Should Kay keep her head down and try to focus on work? Not everyone's going to be comfortable with her gender transition, and she should expect some negative comments and remarks. Or is it B? Kay has a claim for discrimination and harassment because of gender identity and gender expression against the board because of Terry's treatment of her, as well as because of the coworkers' occasional use of the wrong name and pronoun. Those coworkers should be reprimanded and notes placed in their files. Or is it C? Kay has a claim against Terry and the board because of Terry's negative comments and purposeful, repeated use of the wrong name and pronouns. Her coworkers' occasional and accidental mistakes do not create a situation of discrimination or harassment. Well, the best answer there would be C. Kay does have a claim against Terry and the board because of Terry's negative comments and purposeful, repeated use of the wrong name and pronouns. Her coworkers' occasional accidental mistakes do not create a situation of discrimination or harassment. Typical harassment cases Here's some scenarios. An employee is fired or denied a job or an employment benefit because he or she refused to grant sexual favors because he or she complained about harassment. So this is retaliation for complaining about harassment. It's illegal, even if it can't be demonstrated that the harassment actually occurred. Another scenario, an employee might quit because he or she can no longer tolerate an offensive work environment, referred to as constructive discharge harassment case. So if it's proven that a reasonable person under like conditions would resign to escape the harassment, the employer may be responsible for the resignation of the employee, as if the employee had been discharged. Also, there is an employee that's exposed to an offensive work environment. Exposure to various kinds of behavior or to unwanted sexual advances alone may constitute harassment. Well, let's look at preventing and responding to sexual harassment. Quick quiz here. The DFEH can seek injunctive relief to compel employers to take all reasonable steps to prevent unlawful discrimination without proving an underlying violation of the FEHA. True or false? Also, the employer's duty to take immediate effective action in response to a claim of sexual harassment would only apply where there's a credible report or threat of unwanted physical contact. True or false? True. The DFEH can seek injunctive relief to compel an employer to take all reasonable steps to prevent unlawful discrimination without proving an underlying violation of the FEHA. But it's false. The employer's duty to take immediate effective action in response to the claim of sexual harassment applies where there is a credible report or threat of physical contact. Employers must take all reasonable steps. It is unlawful for an employer to fail to take all reasonable steps to prevent discrimination, harassment, and retaliation. A determination as to whether an employer has complied with Government Code Section 12940K includes an individualized assessment dependent upon numerous factors, sometimes unique to the particular employer, including but not limited to workforce size, budget, nature of the business, and the facts of the case. So, policies and procedures and basic steps of investigation. The employer is obligated to conduct an effective workplace investigation of sexually harassing conduct need not be motivated by sexual desire. And legal reference 404, also California State Code 12940K. It is unlawful for an employer, labor organization, employment agency, apprentice training program, or any program leading to employment to fail to take all reasonable steps necessary to prevent discrimination and harassment from occurring. 2 CCR 11203, Harassment, Discrimination, Prevention, and Correction. Abusive workplace conduct. Don't worry, we're getting close to the end here. This is true or false, quiz number 9. The Fair Employment and Housing Act makes it unlawful to engage in behavior that a reasonable person in the employee's place would find demeaning. True or false? Answer: false. The Fair Employment and Housing Act makes it unlawful to engage in behavior that a reasonable person in the employee's place would find demeaning. It actually goes a step beyond that. Abusive conduct. This is what the law says. Conduct in the workplace that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests, including repeated inflicted verbal abuse, such as derogatory remarks, insults, or epithets, verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating, or the gratuitous sabotage or undermining of a person's work performance. A single act shall not constitute abusive conduct unless especially severe and egregious. All right, let's get to a new scenario. Jason, he is a new employee at the authority, and he is having a lot of difficulty learning the office protocols. He asks his supervisor, Ming, for assistance. Ming, in a loud, sarcastic voice, audible throughout the open workstation area, he tells Jason, I've showed you how to do this simply simple, 3 simple step procedure over and over and over. You should have been paying attention. I won't show you again. Well, Ming's actions constitute abusive workplace conduct, and Ming can likely be disciplined for violation of workplace behavior policies. Ming also writes an email to Jason, which reads, Jason, are all Irish mutts as stupid as you? What is it about that thick potato head of yours that you can't understand the most simple instructions? Best answer here. Ming would likely be found personally liable for harassment based on race, ancestry, national origin. The authority is strictly liable for the harassment by Ming, its supervisor. Jason can recover damages from Ming personally, or all of the above. Guess what? It's all of those. Ming can be found personally liable for harassment. The authority would be liable as well, because Ming is a supervisor, and Jason will recover damages from both Ming personally and the authority. No independent cause of action. Let's talk about what that means. Abusive conduct, or in this case, bullying, in and of itself is not a violation of the FEHA unless it can be shown to have been substantially motivated by a protected characteristic. So one of those 17 characteristics that we talked about. There's a possible Ralph Act claim if violence or the threat of violence is involved. And then the DFEH would have jurisdiction to investigate and litigate. Possible non-FEHA claims would be assault, battery, or intentional infliction of emotional distress. And in most cases, that would be investigated by DFEH. So let's review what we've been through here, okay? First of all, let's not harass. Don't do it. A hostile or offensive work environment. Work environment sexual harassment. We talked about the 3 different cases, right? Making unwelcome sexual advances or other verbal or physical conduct of a sexual nature with the purpose of, or that creates the effect of, unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment. This type of harassment typically comes from a coworker. So here it is, sexual harassment. Unwelcome advances, requests for sexual favors, other verbal or physical conduct of a sexual nature, severe and pervasive. We talked about what severe and pervasive is. Making threatening reprisals after a negative response to a sexual advance. So, hey, you're going to get a bad review because you didn't appreciate my sexual advance. Leering sexual gestures, displaying of suggestive objects, pictures, cartoons, posters, unreasonably interferes with an individual's work performance, creates a hostile work environment, focuses on the impact of the behavior, not the intent. Sexual desire isn't necessary, and then we talked a lot about quid pro quo. Quid pro quo, remember, that's this for that. This type of harassment happens when a supervisor or other authority conveys to a subordinate through words or actions that they must engage in sexual conduct in order to advance or to not receive poor treatment. So if you want to get ahead, we need some sex. If you don't want to get fired, we need some sex. Those are all quid pro quo sexual harassment. Conditions and employment benefit or continuing employment on the employee's willingness to perform sexual favors. Discrimination. Illegal discrimination, the definition is: illegal discrimination occurs when someone is treated unfairly because of the protected class status. And those are the 17 points that we went through. Disparate treatment. Two things must be proven. The employee suffered harm, so something bad happened to the employee, fired, disciplined, denied benefits. The motive that caused the harm was related to protected class that the employee belongs to: race, sex, age, or one of those other 17 points. Anytime you suspect or witness or experience any type of harassment or discrimination, it's a violation of company policy. It's also a violation of the law, and it can be by another employee, supervisor, manager, or third party doing business with the company. They should immediately contact their supervisor, their HR representative, or contact us directly at Zomp HR and talk to any of our human resource consultants. And there are the numbers that you can reach us at. 801-377-1190 or toll free 888-819-5952. In addition, if any employee observes sexual harassment by another employee, supervisor, manager, or even a non-employee, the employee should immediately report the incident to the individuals above. Appropriate action will also be taken in response to violation of this policy for any non-employee. So why do we care about harassment? Well, an HR person or manager, owner acting in an HR capacity can be personally liable for their inactions. Failure to address harassment and to do what reasonable people would do can make personal liable for the harassment as well. So there's personal liability in the harassment. Under the California law, any individual can be held personally liable for any type of harassment they've engaged in. The law of negligence defines that the standard as the level of care of a reasonable person would exercise in a similar situation. For example, it's reasonable for a motorist to follow the traffic laws. That would be the reasonable person, including the speed limit. Reasonable person, not an actual person. It's just a phrase used in criminal and tort law to denote a hypothetical person in society who would exercise average care, average skill, average judgment in conduct, and who serves a comparative standard for determining liability. Part of the family of the hypothetical figures in law, which includes also a right-thinking member of society, an officious bystander, reasonable parent, reasonable landlord, or the fair-minded and informed observer. So, we appreciate your participation in this presentation today. Hope this information has been useful. And just remember the elements of sexual harassment and the remedies that are available to the victims of sexual harassment under the California and federal law. Understand that other forms of unlawful discrimination, harassment, and retaliation under the FEHA and other statutes are enforced by DFEH. Strategies for preventing and responding to unlawful discrimination, harassment, and retaliation, and also abusive conduct in the workplace. Here it is, our last quiz. Quiz number 10, true or false? An employer is strictly liable for sexual harassment committed by a supervisor or agent. And let's call this the state of California law, true or false? Only employers with 5 or more employees are liable for sexual harassment under the FEHA. True or false? Sexual desire is a required element of a sexual harassment claim. True or false? Ho, ho, ho. Here we go. True. An employer is strictly liable for sexual harassment committed by a supervisor or agent. So the employer is liable, and the person that committed the harassment is also liable personally. In the state of California, sole proprietors, it doesn't have to have any number of employees. So even one employee would be liable for sexual harassment under the FEHA. And sexual desire is not a required element of a sexual harassment claim. Any other questions? We'd appreciate it if you reached out to us. We can be reached at the phone numbers that we posted above, 801-377-1190. You can also email hr@zamphr.com with any of those questions, and we'll happily respond to them. Appreciate your time and attention today. And with the conclusion of this presentation, you will be able to take the quiz. The green button will light up, and you'll be able to take those 10 questions just to make sure that your comprehension is there. Have a great day. Thank you very much.